control of the 10 new POPs and DDT. There were 12 originally listed POPs in the annexes of the Stockholm Convention. One of them was DDT. In 2009, 9 more chemicals were added to the annexes of the Stockholm Convention, and 2011 another one. So we talk about the 10 new and DDT. The objective of the guidance is to identify POPs as substances or contained in mixtures or contained in articles on the national market and in international trades. So first to identify them, then if you have identified them, to determine their legal obligations under the Stockholm Convention. And third, to guide stakeholders, especially customs, on how to enforce the legal obligations. The target audience is customs to prevent illegal import of banned POPs or severely restricted POPs, but it is also the obligation of companies to avoid illegal import and use of banned and severely restricted POPs. Local authorities are also working to identify at the site of the companies the illegally imported POPs and stockpiles, and they have to prevent illegal POPs production and use in companies. Also, when you do your inventories in your national implementation plan, the national government, when they identify stockpiles of these POPs, they can use the tools to identify these POPs from this presentation, but also there are separate guidances available, especially for brominated flame retardants and PFOS. Okay, so the purpose of the guidance is to give information for countries on different levels of knowledge and development. All countries should have a good understanding of the legal obligations, which we will discuss in section 2.1. For some customs, the customs control procedures that are described in section 2 can be skipped because they already have a very advanced control system. Then the proposal in section 3.4, how to use the data that are available for customs control, can be adapted to national needs, and the supporting documents I will explain in the presentation, and the database available for control could be integrated in existing electronic tools, customs control tools as appropriate. And parties are encouraged to share experience on customs control. Now, what tools do we have for the control of POPs made for customs, for national inspectorates, or for governments doing inventories? First, we have to understand what is regulated if a chemical is in the annexes of the convention. In the annex, there are chemicals listed as chemical substances. So you have a listed POP as a chemical substances, and you see as an example on the bottom of the slide, a listed POPs is, for example, DDT. Then, but besides the chemicals that are explicitly listed, also mixtures produced by intentionally adding a listed POPs are regulated and are, for example, banned or severely restricted. So for a POP mixture, you see in the bottom, which is BioWet FT248 liquid, 50% solution with a perfluorooctane sulfonate chemical, is regulated, although there's only 50% of the POPs listed in this mixture. And also articles that are produced intentionally by adding a listed POP are regulated. And articles are solid things that are made of chemicals, but where for their functionality it doesn't so much depend on the type of chemical, but it's more other things determine the functionality. For example, if you have a glass which is a container for a liquid. It can be out of plastics, and then it's an article made out of plastic. It can be out of glass. It can be out of lead glass. It can be out of metal, and so on. Examples for articles you find in a document which is on the website of the convention under supporting documents. Under terminology, you find the definition: batteries, computers, cars, and so on are articles. So an article which is produced by adding a POPs, and the example is on the bottom of the page: acrylate and urethane polymers of N-ethyl perfluorooctane sulfonamide ethanol for carpet surface treatment. So they are on this POPs is there's a carpet, and the POPs is used to treat the surface of the carpet. So not only actually the chemicals listed, but also mixtures of them and articles produced from these POPs are restricted, banned under the convention. Then there are in the annexes A and B, which is for the intentionally produced industrial chemicals or pesticides, there are some general provisions when it comes to the obligations, what is banned and what is restricted. And POPs, which are for research or as a reference standard in laboratory scale, are allowed still to be used, although a chemical might be totally banned under the convention, like, for example, aldrin or chlordecone as a pesticide. But you still are allowed to export, produce, and import reference standards, which is very important if you want to analyze these chemicals in environmental matrices or in products. And then the convention also allows, when a POPs is listed, for example, like brominated diphenyl ethers, which are flame retardants, that the types of articles that were containing these brominated flame retardants, which were manufactured or already in use before the chemical was listed, can still be used in the country. That means if a POPs is listed and it is contained in articles that are in use already before this POPs ban was becoming efficient, or had to be implemented, then these articles still can continue to be used, actually, if you notify the Secretariat that you use this type of articles still. When these articles are becoming waste, they normally are under the regime of Article 6 of the Stockholm Convention. And then also, if two countries have the same types of articles still in use, have notified that to the Secretariat, then also the trade between these two parties with these articles is allowed. Now, next slide. Now we have the regulatory status of production, use, and trade for the new POPs, which are an Annex A in this table, and I only have those chemicals where there is still any use allowed. So for lindane, there is an exemption from the ban of use. It is for health purposes to fight lice and scabies. So these mixtures are allowed if you have registered exemption. So when you see the table, it talks about chemicals and mixtures, and then it is the trade between parties. And if the importing party have registered with the Secretariat that they want to continue to use lindane preparations for health purposes, and the exporting party has registered, then trade is allowed. If one of them or both of them have not registered, then trade is not allowed. For lindane, production is not allowed at all anymore, but use is allowed, and the idea behind this is that there are still stocks available worldwide for the very, very minor use to produce for the time-limited exemption, which is normally for 5 years for parties who have notified that. And waste containing lindane can only be exported from environmentally sound final disposal. The situation for endosulfan is similar as for lindane with respect to export and import, but for endosulfan now, as there are many exemptions for use for certain complexes of crops, the production is still allowed. Parties have to notify that they want to produce endosulfan for certain pest crop complexes, and then they are allowed to do that, and countries who want to use it have to also notify this exemption, and you can find that on the website in the register of these exemptions and register of specific exemptions. So these are the obligations for chemicals in Annex A, where you had specific exemptions. There are other chemicals in Annex A or B that well, in Annex A mainly, which are totally banned, like hexabromobiphenol, a flame retardant, or chlordecone as a pesticide, and they are not mentioned here because nothing is allowed with them. You just cannot trade them, you cannot produce them, you cannot use them. Then there is another group of chemical, which is PFOS, its salts, PFOS-F, and any chemical that contains PFOS in its structural formula, this element. And for PFOS, its salts, and PFOS-related chemicals, there are so-called specific exemptions. It is listed in Annex B because it has also acceptable purposes. And the difference between specific exemptions is that these exemptions are time limited for 5 years, and then they normally end. They can be extended for another 5 years. The acceptable purposes are also exemptions, but which are not in itself time limited. They are reviewed every 4 years by the parties of the Stockholm Convention and may be ended. And the concept of these PFOS, its salts, PFOS-F, and PFOS-related chemicals is the same as for endosulfan. You can export and trade with both importing and exporting party is notified. You can produce it if you have notified for the register for production, and you can use it if you have notified for the register of acceptable purposes, and the same is for specific exemptions. There is another group of chemicals that are the brominated flame retardants, tetra and penta BDE, and hexa and hepta BDE, and they are banned for production and use, but there are some specific exemptions for them for recycling. They are sort of another difficult domain and very difficult to control and enforce because they would be imported from one country to the other as an article in use. Now, when it comes to customs control, in general, customs, first level of customs control is paper control. In a customs declaration, they check the harmonized system codes. And for some listed POPs like lindane and DDT, there are chemical-specific codes in the harmonized system. The harmonized system is a system of customs, and customs' first job is to collect money. So the HS system is addressing imported goods, including chemicals, meat, machines, and so on. And to the customs code, the customs officer has a list what the duty, how much of the value, 5%, 10%, and so on. But at the same time, due to the Rotterdam Convention, which has a provision of cooperation with the World Customs Organization, for some chemicals, we have specific customs codes. Many other chemicals are just in general harmonized systems, groups like nitrogenated organic chemicals or fluorinated organic chemicals, and so on. So it would cover a big group of chemicals, and so these harmonized system code would not be chemical specific. Well, when you have the information, then you compare the information of the imported good with the available database on POPs. There is a database which is part of this document on customs control, and I come back to that. And you can look at the common name, trade name, harmonized system code, and so on. And what is interesting and what one could do is one could ask from an importer of chemicals if you have the legislation in a country according to this, to ask them to declare that the import of the good is in conformity with the existing national POPs legislation or with the existing national chemicals legislation. So this could be requested from the importer in addition when imported. Well, then there is customs does also inspect sometimes the goods. They do this after basis on a risk analysis. So they select goods for physical examination, and that is in areas where the customs officer, due to a risk analysis, think that breaches of the regulation are likely to occur. Risk indicators can be the commodity code, the harmonized system code, the country of origin, when it's, for example, about PFOS. The main producer on PFOS and PFOS-related chemicals is China. Then there is trader compliance. So you look at traders who have breached legislation before. You look more deeply on them. Part of this document or a supplementary document is a table of potential POP suppliers. If you find the person who exports it to you is a POP supplier, it would be worthwhile to have a closer look at the imported goods. The means of transports, which when you have a strange means of transport, which is for this type of product is unusual, you could have a look and so on. So that is the second level, which is the inspection of the good. And then when you actually inspect the good, you can make use of something with the labeling of the packaging of the container or the goods. The major transported containers should be labeled in accordance with the UN recommendation of the transport of dangerous goods and could contain a UN transport number. Then within the big containers, there could be smaller containers of the goods, like bottles or boxes or so. And the packages should be labeled in accordance with the UN Globally Harmonized System of Classification and Labeling. So if it's a POPs, which is a hazardous chemical, this so-called GHS system looks at hazardous chemicals. All POPs are hazardous chemicals. So you should find the CAS number, the chemical names on, and also the supplier identification name, address, telephone number. And for POPs in mixtures, you will find the chemical name and the CAS number mainly often in concentrations above 0.1%. There is in the GHS a level which says that for certain properties in the mixture, any component in the mixture above 0.1% has to be indicated on the label with CAS number and chemical name, and that is this 0.1 is for highly acutely aquatic toxic chemicals, for carcinogenic, for reproductive chemicals, and POPs have, all the POPs listed have at least one of those properties, so they should, if the GHS is applied, should be on the name, on the label of the mixture if it's there in above 0.1%. So the third level of customs control is a laboratory analysis. So customs services that have access to laboratories can analyze, but this is mainly done to verify the harmonized system codes. The harmonized system codes, as I said, is often not chemical specific, and so the normal customs analysis does not reveal the chemical identity, but the chemical class. And so what one could do is, if one has certified laboratories available to check for specific tests, POPs in some materials where the designation is uncertain or unclear, but where you expect these POPs to be in there, and then you can use these results for your enforcement. Okay, I talked about supporting documents for the control of POPs, especially the import control. There are, when you go on the website of the convention and you find the documents on customs control, there is a box called supporting documents, and then some of the supporting documents are supporting documents for this customs control. One is information on the legal obligations. Then there is an example of all the obligations for the trade of lindane. The summary tables that summarizes the obligation of some POPs you've seen in the presentation. Then there is a list of possible producers and suppliers of all POPs. There are actually two lists, and this is an internet-based search I did, and there is one list of possible POPs producers and suppliers in bulk form. And as I said before, small quantities which are used as standards or for laboratory use are exempted. And so we have a second list of suppliers of these standards. So actually only when you find producer name or supplier name in the first list for A, then this is an indication that this company might export a POPs to you. If it's in the second list, it is most likely that it's a laboratory standard, a reference standard, which is allowed. And then there is a database available with 3 Excel tables. There is information on the newly listed POPs DDT, common name, chemical name, CAS number, harmonized system codes, UN transport number, trade names, company names, classification and labeling details for the harmonized system codes. There are mainly the harmonized systems codes which are chemical specific because any chemical can fall under a harmonized systems code, but this is not very useful actually for the control, as many hundreds of other chemicals can be in the same class. Then we were talking about PFOS, its salts, PFOS-F, and so-called PFOS-related chemicals. PFOS-related chemicals are those chemicals which have the PFOS element in the structural formula and were produced through PFOS-F as a starting material. And these names of these chemicals, chemicals group, are not explicit in the convention text in the annexes, but there is a list of 160 possible chemicals with sometimes with trade names and company names in another Excel table. And another list is that chemicals that are contaminated with POPs are identified. Then how to use the guidance. I mean, the data that facilitate identification are if you have the chemical name and CAS numbers in substance or mixtures, for example, after inspection of the label, then that is the easiest access. This is chemical specific and you can easily identify whether it's a POPs or not. When you have the harmonized system codes, when it's specific, then for a substance, then you can also immediately identify the POPs. But for example, for lindane and endosulfan, where you have chemical-specific codes for the substance. The mixture is just the mixture code is just the same for any pesticide, so it's not very specific. Then there are trade names, which are common names, generic names, which for POPs, substance and mixtures or articles, and you find it in the database, UN numbers, and the classification and labeling, and information on the supplier where you can look at the database. Okay, so how do you use that information? And it's very simple. You collect your information and you search it in the database. And this is not only valid for customs. If you have the classification labeling, if you control in a company, you can also in companies control the issue. And then an example for a risk analysis, for example, if the harmonized system code chemical class says contains bromine or chlorine as POPs do, you could have a more closer look at the actual good that is supplied, or if the supplier name is found in the list in this Annex 4A, the good could be inspected physically, just as an example. So when you have the inspected goods, look at the label according to the GHS, name, test number, supplier, and so on. And then if you have identified the POPs, check whether it's legal to be imported. Because as I said before, there are exemptions for lindane, for health purposes, for some pesticides, for endosulfan, for crop pest complexes, and for PFAS, there is a large number of exemptions. So if you haven't identified a POP, it doesn't mean you take action. You first check what's the legal situation. Then in some countries, and often in developing countries, it is required to have an import permit or license. That means the importer has to go to an authority to identify the chemical good, and the Ministry of Health, Ministry of Environment, and so on. And they would sort of say, yes, this is allowed, looking into the list of banned and restricted chemicals, and so on, and would allow import and would give an import permit, which then facilitates work of customs. But at the same time, as this permit license only works if people are not cheating, if they don't give you wrong information. Also, the people who give permits should very clearly have an agreement with the customs who does what. Would customs, even if there's an import permit, do a risk analysis to identify violations or not? And but anyway, customs could be obliged for permits to check the good all the time, whether the chemical name on the label, the use, and the physical appearance is consistent with the identity given by the importer. So this was an overview of the guide on customs. Actually, it was an overview on what are the obligations of the convention, what are the obligations for the different chemicals, how can the chemicals be identified, and on the supporting documentation that is available. So thank you very much for your attention, and sorry for taking so long, but there were several presentations in one.